factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanow would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled, should be done on a question-by-question basis.
So your expectation is for me to ask the question, she will make some sort of signal, I'm invoking, the jury is to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Laura, last word, and then I will rule.
Yes, Your Honor. The statement by counsel is patently incorrect and false. This issue was raised by Ms. Carras in the McManawar trial. She preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA, and we respectfully request that Your Honor follow that ruling here. There is simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
All right. Having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time, but I do believe it is the proper ruling at this point to quash the subpoena. Mr. Laura, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That concludes the public portion of the hearings for this afternoon. We will take a brief break and then resume with the in-camera matters. The courtroom is to be cleared by all non-parties at this point.